Okay, now the Bundesgerichtshof, a Federal Court of Justice of Germany, has decided on the well-known DABUS case. I'll try to explain it, and the DABUS case raises a number of questions, and I think that's a good way of getting into the matter. Now, what is the DABUS case about? Inventions generated by artificial intelligence. That happens more and more often. I will not show examples today, but I have shown examples a number of times, and if you have questions, I have a collection of examples. So it happens more and more often. And one of my clients has developed a machine called DABUS, and this machine made an invention, and he wanted a patent granted for an invention by his machine, which would at least help raise his reputation, at least. That's interest enough for him to ask for a patent. And it was his wish that his machine be recognized as the inventor. Now, were we able to fulfill his wish? We'll see now. We filed this with a number of patent offices, among them the German Patent Office. They refused it. They said, you cannot name the machine as inventor. Then we went to appeal to the Bundespatentgericht, the Federal Patent Court, and we filed a number of auxiliary requests that were quite important for this case, and I'll get into that. And we were quite satisfied with the result of the Bundespatentgericht, but not 100%. And also even the Bundespatentgericht asked us to file an additional appeal to the Bundesgerichtshof, so that the Bundesgerichtshof gets the chance to deliver his opinion on this case. So, okay, we did it, and now we have what the Bundesgerichtshof said. Now, I'll show you two introductory slides. One is concerned with the questions raised when Stephen L. Thaler, my client, wants his machine DABUS recognized as inventor. Now, the questions raised are, okay, number one, some people even doubted that machines can generate inventions. Such a question might legally be asked in a correct manner. If you ask what is inventing, and this sort of questions is very important perhaps in the US, not so important in Europe, because an invention is a technical teaching, and if a machine generates a technical teaching, well, that's an invention. So I did answer that question, but we'll see what the Bundesgerichtshof said to that. The second question is, well, if we have an AI-generated or computer-generated invention, is such an invention excluded from patentability, from patent eligibility, because it was generated by a machine and not by a human? Is patent law here only for inventions made by humans? Third question, even if the answer to this second question might be no, patent law can also be for machine-generated inventions, still the question will come up, do we need a human anyway? Okay, question number 4, if we need a human, just assuming that, and we will have the answer, of course, very soon, well, then the question is, well, who is it? If it actually was the machine, so which human can we designate as inventor? And a detailed question within this question is, does that human need to make a creative contribution to be recognized as inventor? Or what does that human have to be recognized as inventor? And if there's nobody who made a creative contribution, so if we have to identify somebody, but we can't identify somebody, so what then? And then there are other questions which we will not dig into today because they were not touched by the Bundesgerichtshof, which was clear. Inventor step, although the Bundesgerichtshof makes a side remark, but let's see. And then inventor remuneration, of course, is a question that many people raise. Okay, to understand the judgment of the Bundesgerichtshof, it is important to know the requests that we filed. I made this with my colleague Markus Rieck. So the requests that we filed were: number one, main request, DABUS named as inventor. So we filled in the form sheet for inventor designation where it was DABUS. I think at some point we gave it also an address. Okay. Second request, because I mean we over time we understood that this might not go through, so we filed an auxiliary request and named nobody, saying that there's no human who qualifies as inventor. Well, a good try. Then we filed a second auxiliary request naming Stephen L. Thaler as the inventor and mentioning in the description that, but actually the invention was made by DABUS and not by Stephen L. Thaler. And finally, our third auxiliary request is designation of inventor Stephen L. Thaler, who made the arrangements for the artificial intelligence DABUS to, I have so many things on my screen here, to generate the invention. Okay, fine. The Bundespatentgericht allowed the third auxiliary request. We actually thought that following the European Patent Office, who had made a side remark, that putting something in the description would be the better solution. Okay, so here. Now the Bundesgerichtshof has to and took the case request by request. So they started with a main request and they said a couple of things concerning the main request. Let me see whether I can get the right document on the screen now. Yes, it should be this one. Yeah, so this is a machine translation of the judgment. So here is everything that was above that was only explaining what the matter is about, and here starts the reasoning. And the first point is an inventor within the meaning of Section 37 German Patent Act can only be a natural person. The reason for this is, which we have learned from J8 out of 20 from the European Patent Office, that the rights are only generated if we designate a natural person. So that's not such a big surprise. And if we try to go back to the slides, that already answers, that answers question number 3. Do we need a human inventor? Yes, we absolutely need a human inventor. Under current patent law, and I don't think that there is any intention to change current patent law, but the idea of an inventor was only introduced in patent law worldwide, and namely in Germany, in the 1930s, as a consequence of a revision of the Paris Convention. Before that, there was only an applicant. And if you have only an applicant and you have an invention generated by a machine, well, then you file it, you name you just name the applicant as applicant, and that's it. And the rights are allocated to the applicant. That's how it was at the beginning of the 20th century, but it was changed in the 1930s. And ever since then, we have to name an inventor. And that collides with this case where we don't have a human inventor. At least we thought we don't have a human inventor until the Bundesgerichtshof explained us what you will see. Okay, so we need a human inventor. Not mentioned terribly explicitly, but it is clear that computers can generate inventions. For the Bundesgerichtshof, it is clear. And is it excluded from patent protection? No, it is not. Because otherwise they should have said that there's no way. Well, whatever you do, there is no way, which they didn't. So let's go on. What do they say in the judgment? Only the inventor can be the holder of a right in the first place. And then it moves on from the inventor to his employer and so on. And then, of course, they have to tackle the question, which human being might be the inventor for a computer-generated invention. So here they say, according to the case law of the Senate of the Bundesgerichtshof, the status of inventor is not only the result of an actual process, which is the traditional definition. Inventor is the person that actually devised the technical teaching. That's the traditional definition, which doesn't work for this case. So namely the discovery of a new technical teaching, rather it also includes legal relationships. And that's where we have to go now. The designation of a natural person as inventor is also possible if a system with artificial intelligence has been used to find the claimed technical teaching. Okay, a system, how do they call it? A system with artificial intelligence obviously seems to be able to find technical teachings. But even then, it is possible, you have to, and it is possible to name a natural person. Now here they make a side remark on inventive merit. Let's skip that one. Very important. Such an assignment of a certain human as inventor of this computer-generated invention does not require a contribution with independent inventive content. Well, some people have argued in literature during the past years that and it is in the US like that. Only if you make a creative contribution, you can be assigned inventor or co-inventor, as they kind of call it in the US, for a computer-generated invention. So in the US, it's not enough to start the machine, to ask a question to the machine. You have to make a creative contribution. Not in Germany. And I would assume the European Patent Office and other European countries will likely follow what the Bundesgerichtshof wrote here, because the Bundesgerichtshof follows what these other countries have said so far on computer-generated inventions. I would presume a European harmonization on that. So you need not make a creative contribution to be so that you might qualify as inventor of this computer-generated invention. Let's see what they say here. A human contribution that has significantly influenced the overall success. So not creative contribution, but influenced the overall success is sufficient for the status of an inventor in a technical teaching that was discovered with the help of an artificial intelligence system. So what you need to do is to influence the overall success. Well, there are different ways how you can influence the overall success: by posing a question, or by buying the machine, or by starting the machine, or different ways. We might get into that a little bit. The Bundesgerichtshof doesn't say much more on that topic, actually. Regardless of how these questions are to be assessed, it remains possible to identify such human contribution, even when using systems with artificial intelligence, and to derive the status of inventor from this through legal assessment. So it's not a factual, classical factual designation of inventor because that person derived the technical teaching, but it is a legal kind of allocation. Now here is a very important statement. According to the current state of scientific knowledge, there is no such thing as a system that searches for technical teachings without any human preparation or influence. Now, okay, some people will say at this point, oh, they are too conservative, they're not going far enough. Others will say all the time they're going too far because they think that artificial intelligence is a danger. Now, of course, such a statement can be criticized. Is there really nothing out there that can't act independently? Well, I think the objective answer is yes, there are systems out there that can act independently of human beings. DABUS claims to be such a system, but I think we have to take into account that the court has to apply the existing law. And what they are trying to forge here is a practical solution to the problems posed. They want to open the door for patents for computer-generated invention, and they have to show a way. And as patent law stands, there is no way without a human inventor. That's how patent law is written today. If you want to change that, you have to change patent law. What they do is try to squeeze this case into existing patent law, which is fair enough, That's their job. So, and therefore they say there's always a human around. And I think the solution they are ordering is good enough for practical purposes. So we have to find a human that's around, that's close, that made a significant contribution to the success. And in practical terms, almost always will we be able to get that. In the current case, DABUS, Stephen L. Thaler, Stephen L. Thaler is all around. He built the machine, he started the machine, he did everything. So he's the one to designate. Okay, let me see. Yeah, that was the answer to the main request. You have to name the human inventor, and you can name the human inventor. Well, then the judgment moves on to our first auxiliary request where we said, there's nobody, please let's skip the designation of inventors. And this fails, of course, this fails for the same reason, because if you don't designate anybody, there is no right to the patent generated. So it doesn't work. You must designate a human being as inventor. So that failed. Then came our second auxiliary request. And actually, I wanted them to accept our additional paragraph in the description, but they didn't. And they did not do this for one reason, which is very consistent within their reasoning now. Because we say in the designation of inventor, it's Stephen L. Thaler. And then in the description, we say, no, it wasn't him, it was DABUS. And they don't like it. They don't like this contradiction. And what they say is, as explained in the main request, you have to designate a human, and you can. And this human being had an influence, a decisive influence on the success. So what we should have written, and we didn't because we didn't know before this judgment, we should have written in the description, well, the inventor Stephen L. Thaler used a certain machine called DABUS to derive the invention. Then I assume it would have gone through. But we didn't know, and our wording was wrong, and so it did not go through. But they concurred with the Bundespatentgericht in allowing the third auxiliary request. They say, I'm not putting this on the screen now, they say there is no reason to reject the application under this formal examination with such a designation of inventors as we wrote here. Stephen L. Thaler, who made the arrangements for the artificial intelligence. They say this is irrelevant, but it's not wrong, and it does not exclude patentability. So that's basically what I think the judgment says. Let's go back to the questions. So which questions did they answer? Can a computer-generated invention? We said it already. According to the Bundesgerichtshof, yes, they can. And according to me and others, yes, computers can. Some programs, some systems can. Is a computer-generated invention excluded from patent protection? No, it isn't. And that is the most important result achieved here. You can get a patent on a computer-generated invention. And this is a very practical result because computer-generated inventions are a reality today. They have even been a reality years ago, decades ago, and they are becoming a reality more and more these days because more and more systems exist that help you generate inventions. I will not cite names now, but there are systems out there that you can buy a license from and they help you generate inventions. And then the question is, okay, can you get a patent? Yes. But how do I have to handle them? And here we have now the guideline from the Bundesgerichtshof of what you have to do. Third question is answered. Do we need a human inventor? Yes, we do. Who can be identified? Well, the Bundesgerichtshof said somebody who had a decisive influence on the success. Let's dig a little bit deeper. Oh, yeah, number 5, does that human inventor need to make a great contribution? No. Let's dig slightly deeper into those persons that might be considered as inventors. Now, they must have a decisive influence on the success. The success is the invention. Okay, there are, on one hand, creators of the artificial intelligence, users of the artificial intelligence, and kind of post-production people who receive the results. Now, this is a kind of temporal ordering. Now, the creators might be the programmer or the trainer. The person who recognized, maybe who selected out of maybe 10 suggestions that the machine made, as a human being says, well, number 5 looks best to me. A possibility. And then on the user side, there's somebody who poses the problem and saying, can't we ask the machine to give us a solution to this particular problem? And maybe there is somebody who controls the machine, who knows how to handle this machine. So all these, according to the Bundesgerichtshof, according to my understanding, might qualify as human inventors. They must have a relation. If somebody is totally unrelated to the generation of the invention, that person cannot qualify as inventor. But any of these, and maybe there are even other rows imaginable, they might qualify. The CEO who said, let's buy a license, is not so well positioned. A CTO who said, let's see what the machine suggests, is much better positioned to be recognized as human inventor. I have, among these roles, I have personal preferences and people I would actually not consider, namely those who created the AI. I would not consider them to be inventors in a particular invention, because, I mean, if somebody builds an AI and licenses it or sells it to somebody else, and that person then makes inventions, then they would always be co-inventors or inventors probably co-inventors. On your client side, I don't think that's practically not so interesting. But the other 3 might be okay. My clear preference is the person who caused the problem. But in the end, it might come down to the individual case on what is the best idea or not. I think that's about what I wanted to explain. Nothing